Hi everyone, this is Art Matthews. I'm an attorney with the Matthews Law Firm in Tustin, Orange County, California. Sorry for the delay and technical issues I was having on my end. So today I wanted to talk about some contract do's and don'ts. I'm sure most people on the call have at one time or another entered into some form of a contract, whether it's business or personal related. So I just wanted to kind of pass along some nuggets of hopefully information that will help you guys down the road. So the main issue I see when people try to draft their own contracts is when people try to draft their own contracts, I should say. So, if it's a promissory note or if you have a business and you're selling a product or a service, you should really have an attorney, someone experienced with, business contracts, take a look at it and draft it for you. That would be the best thing to do before you start putting it into circulation and making it a legal document when everybody signs it. I have like a number of horror stories I could tell. Like I recently still have a client we're suing on a promissory note, and so he used like a LegalZoom promissory note or something like that, and he was friends with the person he lent about over $120,000 to, and they got together to negotiate the terms. He had the full-fledged, promissory note with all the terms laid out, and he let the borrower cross off a bunch of terms, thinking he didn't need them, and it basically made almost the entire contract unenforceable. So now, most promissory notes have what's called an acceleration clause. So if you miss one payment, the lender can, and probably most people are familiar with this, if you miss one payment, the lender can accelerate and say, okay, you owe the whole thing now. And so when that acceleration clause was crossed off, that meant that the lender has to sue each month or wait 6 months and file a lawsuit, or maybe wait 3 years and file a lawsuit. So he really didn't do himself any favors by not having someone with experience look at it before he allowed his friend to cross off all those important terms and go ahead and sign it. So another example I had is, in a recent business case, the clients had a lawyer draft like a template of a contract, and they told, they just wanted to go cheap, and they told the attorney, well, just draft a base contract. They didn't tell her very much about what was going on. And it turned out that when they tried to fill in the terms themselves, they just did a terrible job. And then they hired me, and we ended up, this was a situation where the borrower and the lenders were friends, so we were able to just amend the original contract and fix it. But if they wouldn't have been on friendly terms, our lender, who had lent over $250,000, would have been in trouble. He would have waived a lot of his rights. So, I don't want to offend anybody. It's just like when I go to the doctor, I don't pretend that I can diagnose myself. And it's the same thing when you're talking about legal issues. You shouldn't, you should kind of leave it to a professional. And you're not doing yourself any favors by trying to do it on the cheap, because all it takes is one time where maybe you'll get away with it a number of times, but all it takes is one time where you have a person you have an issue with, and if you have a contract that turns out to be unenforceable, it could cost you, if you've provided $30,000 in services and you can't sue to enforce it, or there's other issues, it's going to cost you way more than it ever would have cost you just to have an attorney draft like a good base contract that you could use going forward in the future, just changing names and dates and things like that. That's what we do for a lot of our clients, is just if it's a services agreement, we lay out all the terms, and all they have to do is change the names, the name of the people they're contracting with, the date of the contract. Sometimes if the price changes, there's easy stuff to change, and you can always, they can always send it to an attorney or to me to look at it, just to make sure that they haven't done anything wrong. So the other thing to remember is when people try to draft their own contracts, they think, I can understand it, it's in layperson's language, but if there's ever a dispute, it's going to be looked at by a judge or an arbitrator, and both these folks are lawyers, by training, and so they're probably going to hold your contract to a higher standard than you might think. So again, not to beat a dead horse, just the rule of thumb is to just have someone who knows what they're doing look at your contract, set it up, preferably draft it, and in the long run, I assure you'll save money down the road, and it'll be to your benefit. Now, there might be a contract here or there like that are of low value. If it's for $1,000 or something, there's times where if it's low value to you, maybe you don't have an attorney look at it and you just take a chance. But if it's something that's significant to you that it would hurt you if you couldn't enforce this contract, or if this contract was enforced against you, you definitely should have somebody look at it to protect your interests. Also wanted to talk about some, if you do try to go on your own, or just things that you should look out for, are different provisions that should be in pretty much every contract that you sign. So the first one that I would point out is a venue clause, and the venue clauses talk about where if there's a dispute, if we have to go to court or arbitration, where that is going to take place. So oftentimes I deal with manufacturers, service providers that have clients in all 50 states. So in a situation like that, you don't want to be, the general rule in most states is you sue the defendant where they are located. So if you have a party that's breached a contract with you and they're in New Hampshire, it doesn't matter that you're here. It matters that they're in New Hampshire, and most likely you're going to have to go to them and file suit in an unfriendly court, a court you've never been in, or you have to you probably don't know any lawyers in New Hampshire. So a venue clause just provides that if there's a dispute, venue is Los Angeles County, Orange County, wherever you guys want it to be. You just pick. And so you just want to make sure that you have such a clause in your contracts. Otherwise, you could be chasing someone halfway across the country, or even I've had contracts with folks in China. You don't want to have to go to chase them in China. You want to be able to use the courts in California, preferably. Another provision that I see missing all the time, because people have a misperception about it, is an attorney fee clause. People think that if they file a lawsuit, they get their attorney's fees, but that's not necessarily true. You're not entitled to your attorney's fees unless there's a contract. If it's a contract dispute, you're not entitled to an attorney's fees unless your contract says that if there's a dispute or a suit to enforce or interpret the agreement, that the prevailing party gets to recover their attorney's fees and costs. So people are always surprised to hear he didn't pay and I don't get my attorney's fees. No, unless you put that in your contract, you're not going to get those fees or costs. So super important, when you're talking about a $10,000, $15,000 contract, if you don't have the ability to recover attorney's fees, it's kind of at the point where if you have to pay an attorney $10,000, then it makes no sense to bring a suit. And I see a lot of people without those attorney fee provisions decide just to walk away because it doesn't make economic sense to pursue something like that. So very important to have an attorney fee clause in your contracts. Payment terms. A lot of times people don't have clearly set forth payment terms, like when is payment due? Is it a balloon payment? Is it monthly? So again, just make sure again, this is a reason why you want to have someone look at it who knows what they're doing. Just make sure your payment terms are clearly set forth. Is it a monthly payment? Whatever it is. If it's a service contract, is it 30 days from your invoice? Is it due upon receipt? A lot of times people don't put specifics in there, and if you have to, worst case scenario, go to court to enforce it, and there's no specific period of time when the invoices are due or your services need to be paid for, the court is just going to imply a reasonable period of time. And what does that mean? Well, your guess is as good as mine. So let's take out all the uncertainties there and just be specific when you're talking about your payment terms. Penalties for non-payment and interest. So if you're the one that thinks that you're going to perform and the other side might not, you want to have maybe a little bit of a hammer in there. In addition to an attorney fee clause, you want to have penalties for non-payment. So maybe it's a finance charge, maybe it's interest. In California, interest is generally set at 10% per year. But for if you're providing a service or selling a product, you can charge finance charges in excess of that. So that's a good thing to have because it can increase the amount that's due, and it gives you room to negotiate if you want to try to resolve it. Start and end dates. A lot of contracts don't have end dates. They don't even have a start date. So it should have an effective date right there on paragraph 1, and then somewhere in the body of the contract there should be a termination date. Contracts can't last forever, so they usually have a termination date. You can have like an auto renewal clause, but maybe it's a 12-month agreement and it auto renews for successive 12-month periods if no one cancels. So you want to make sure you have a start and end date in your contract. Big thing I see in a lot of contracts is people might have an LLC or a corporation, and yet when they go to prepare the contract, the signature block where they sign just has their own name, and it doesn't say that they're signing on behalf of the LLC or a corporation. So the reason you form an LLC or a corporation, or one of the main reasons, is to protect yourself from individual liability. So you want to make sure the corporation or the LLC is the party that's doing the contracting, not you individually. So make sure you put the full corporate name or LLC name in the contract, and in the signature block at the end, make sure it says XYZ Corporation, a California corporation by John Smith, president, whatever title you have, just so it's clear you're signing on behalf of the corporation. You're not signing in addition to the corporation or instead of the corporation. What about form contracts from like LegalZoom and stuff like that? I've used them sometimes if I don't have a template of something, just as a base to get started with, and I think they're fine for the most part. Again, if it's something that is routine, like a promissory note or a will, something like that. But if you're talking about something more complicated, like a service contract, manufacturing agreement, if you're selling a company, obviously you don't want to use, I wouldn't use a form contract. You need like a human being to look at it and draft it preferably. What about the form contracts from large companies? Like, you sign a contract with Verizon or, things like that. Obviously I've signed Verizon contracts and, different with the phone company, the power company. You're not going to sit there and negotiate those. But if you're signing a contract that, my advice would be, if you're signing a contract that is important to you, whereas if it wasn't performed or if it doesn't work out, it's going to be a big deal for you. I wouldn't just take a contract that someone else provides for you, like a construction contract. Contractors have a lot of times have contracts that are very favorable to them. Everything's negotiable. If you're doing some home improvements, anything like that, dealing with a contractor, other service provider, manufacturer, you can negotiate it. If there's terms that aren't in there or that should be, like some of the ones I've talked about, or if there are terms that you disagree with, you can negotiate it, you can change it. So don't let anybody tell you it's not changeable. I think Mary said that there really aren't any questions, but I'm happy to answer questions offline. I don't know, Mary, if you provide my contact information or if I do it. Also, I'm happy to email anybody who would like it, just an outline of what I discussed today, just so they have kind of the bullet points that I went over. Anyways, thanks for all your help, and nice talking to everybody.